Oh.
Did you ever get that comeback coming in?
Yeah. Big toss.
Thank you. Too long.
Are you sure? Did you copyright? Did you cite me on it or on this week?
Yeah, it seems like a word.
You transformed me enough.
Transformed into sound of
I gave my for peer review to Did
Did you just say
I gave it to
Did you make the proposal?
no, I know.
Oh.
I gave it to my
All right. Here we go.
coworkers, but he used to be a youth judge.
So,
So
actually,
right.
All right. Good evening, everyone. How's everybody doing this week?
Good. How are you?
Doing good.
Surviving.
You hear me, Trish?
Yes, I do. Thanks.
All right. If you guys check your email, I sent a document with my notes, so you guys have it. It's going to be pretty much the same thing that's on the PowerPoint. So you're going to check, make sure that you have that ahead of time. I'll give you a disclaimer up front. My notes can be a little bit bizarre at times. It's just the same thing I'm working off of. So a lot of times they might have things like my general thoughts or things to cue me in on certain talking points. If you see some bizarre stuff in there, that's probably what you're seeing. But I figured having it can only help because it's kind of a summary of a lot of the cases. The PowerPoint really distills it down. And what's on the PowerPoint should be the same as what's in the notes, just maybe a little bit less than what's in the notes. So, because I know, Trish, you're probably not going to be able to see the PowerPoint. We're going to work on getting that onto this thing, which I think you'll have access to. But
Great.
as you can see, it's working wonderfully. We'll get there.
Okay. Awesome.
All
Thanks.
right. So, right to counsel. This is kind of an important one because without this right, you wouldn't really see a whole lot of stuff going on with any of the other rights, because if someone doesn't have an attorney, how do they know how to assert their rights or what to bring up, what to talk about, much less present it to a court of appeal in the proper fashion to even get it past the courts. So once you have the right to counsel, then basically everybody's getting an attorney. All of their potential rights are being looked at, examined, presented to the court in theory, and then litigated at the higher level. And that's how we have all the case law that gives rise to most of the rest of the book. Historically, this is only for minor offenses. We didn't want attorneys getting in the way of important prosecutions. By the time of the founding of the U.S., England had recognized this right. It carried over to the colonies, but nobody really has. They have the right to retain counsel, but nobody's getting it appointed for them. So it's just kind of the historical perspective. So at a certain point, you could hire an attorney for minor things, like minor offenses, but the crown, so to speak, wouldn't be happy about an effective attorney getting in the way of something maybe of national security or somebody who might have caused the king to lose space, and they want to be able to control the whole proceeding. So remember, we talked kind of about the Constitution being this paranoid document, right? Like what could happen if certain rights, or if we don't have certain rights, right? The ability to kind of control the situation, or what we kind of call today is driving the narrative. If the other side doesn't get to talk, if they don't get an attorney to help them present their case effectively, then the crown would have the ability, or the government has the ability to basically dispose of anybody as they will. And that's kind of some of the problems. That's what they had originally. They didn't want people to be able to present themselves effectively. Once a case was leveled, they wanted that to be the end of it. Because if the crown is bringing cases against individuals and they're not successful, it's going to embolden people to maybe speak out against the crown if they know that maybe they can't end up with a conviction, maybe they don't have much to fear. By the time we have the 13 colonies, we do have the right to retain counsel, so you can hire your own counsel if you can afford them, but nobody at that time was talking about, what do poor people do if they can't afford their own attorney, right? They're not just going to be given one in the average case. Originally, you'd see stuff, just capital cases would be the main thing. I think we'd see, is it John Hamilton or John Adams? They had that HBO miniseries where they dealt with one of the founding fathers that was representing people in the Boston Massacre. No one saw that one? No. It's been a few years since I've seen it, but some capital cases when people are at risk of losing their life, that would be situations where you'd see like, all right, this is serious enough that we're going to give them an attorney to help them represent themselves. But anything less than that, people could be in prison for years, decades, and they wouldn't have been given a right to an attorney. Johnson versus Zerbst came down in 1938, giving the right to appointed counsel in federal cases. So if you think about it in the grand scheme of things, that's not that long ago, less than 100 years ago, for federal offenses to be basically given an attorney if you can't afford one. We have Betts versus Brady. Does anybody want to take that one?
I'll take it.
All right. Before we start, just give you a heads up. I didn't tell you this last time, right? This text does tend to give historical perspectives. You'll usually see these at the start of a new section. So if you start reading one case, and I know how it is when you're reviewing cases, you guys have 3 classes, you probably have about 9 hours worth of reading per class, roughly. You're doing this late at night, you'll read a case, and then the very next case you read it, and you're thinking, isn't this saying just the exact opposite of the case I just read? Sometimes the answer is yes. An easy way to look at that is to look at the dates that are involved, and you see one of them is later in chronological time, or look at what court is deciding. Are they deciding on the same federal issue, or is one dealing with the state issue? Here we'll have historical perspective, so you might get a case where you're reading it says one thing, and then they change to the exact opposite in the next case. You're not losing your mind, you're not delirious, it's just I'm trying to show you how things have evolved. Isabel, if you want to take it away.
Okay. So the facts in this case were that Betts was poor, and he was indicted for robbery in Maryland. He asked for counsel, and they denied him counsel, and they said that the Maryland law was that you only got an attorney if it was for a rape or a murder. So he pled guilty. He asked for a trial without a jury, and he called his own witnesses, and he was still convicted and sent to prison for 8 years. So then he appealed, arguing that Maryland's refusal to appoint counsel was a denial of his 14th Amendment rights of due process. And so the question was whether the constraint made by the amendment upon national court expresses a rule so fundamental and essential to a fair trial, and so to due process of law that is made obligatory upon the states by the 14th Amendment. And then the court goes on to talk about Powell v. Alabama, which is a 1932 case where ignorant and friendless Negro youths were arrested and charged with, I'm not sure if it's a crime, but it was a capital crime. And the federal courts said, in that case, they said that the federal courts must appoint counsel for all federal crime. And how that the defendants in a capital case cannot be denied their right to counsel in federal cases. Here, the court says that although they must appoint counsel for federal cases, the states don't have to appoint attorneys for all indigent defendants. And so they affirmed the lower court's decision. With the rule, I found it on page 67 towards the bottom, where it says, while want of counsel in a particular case may result in a conviction lacking in such fundamental fairness, we cannot say that the 14th Amendment embodies an inexorable command that no trial for any offense or in any court can be fairly conducted and justice accorded a defendant who is not represented by counsel. So basically he's saying that the 14th Amendment doesn't bind the states to the law, just the federal government.
Good. So this is 1942. So this is the state of the law at the time, right? So you have one case, Powell versus Alabama, that says you're going to get it in all capital cases. You have it through the Sixth Amendment in all federal cases at this point due to Johnson versus Zers. Everyone else is totality of the circumstance. Everything's going to be looked at on a case-by-case basis. Totality of the circumstance is a very amorphous standard. What arguments can you come up for? What arguments can you come up against? So you can imagine you can have somebody who might be mentally barely even there, but if they're there on like a low-level misdemeanor offense, then the court just might say, well, it's just not that serious. Maybe we don't want to give this person an attorney at all. You might have somebody with a high school diploma, on the other hand, who's charged with a robbery, maybe looking at a decade or so, and the court says, well, I graduated high school, that's a pretty decent amount of education, that's fine. So that was the state of things at the time, and this is at a point where, we talked last week about selective incorporation. We can see some of the effect of that. They haven't incorporated the right to counsel through the 14th Amendment to be wholly applicable against the states at this point. It's just a case-by-case basis. It isn't deemed fundamental, so not everybody has it, and this is where it's at. The dissent is basically taking the opposite approach. They're saying we think it's fundamental, everybody should get it, but that's not where they're at the time. So notes, appellate counsel didn't point out any specific prejudice at the trial court level, anticipating the principles underlying Zerps would win out. This might have been a fault at their part, right? So they're just saying he didn't have one, that should be good enough, instead of looking at, analyzing everything that went wrong in the case, various problems that he had. Maybe if he was like, he had a potential witness that he didn't call because he didn't know how to subpoena them properly, or documents that he couldn't get into court because he lacked that training and education, and if they were necessary to the trial, spelling everything out. This is one of those underlying principles in the law. Raise every argument you can. If you fail to raise them, they're waived basically, and it's done. The court's not necessarily going to make arguments for you. And when it comes to objections, you fail to raise them and they're waived, right? So make sure to bring the arguments you can. Don't just expect to win anything. Had that lesson a few times. You had that motion you just thought was great. Like, I got 3 witnesses, I have like 4 more I could call, but these are good. I'm pretty solid here. It's like, well, if you're adding something different, maybe it's best to just bring them all. If the court wants to shut you down at a certain point, they'll shut you down, but if you don't bring them, then they're not helping at all. let's see. At this point, there wasn't really a full requirement that counsel be appointed in all capital cases that had been building. It was just largely kind of assumed at this point. The court wasn't making determinations of prejudice. It was usually just implying it in a death penalty case. They didn't have an attorney. And again, as mentioned in the lead up, at this point, anybody, if they wanted to hire an attorney, they would be able to. They wouldn't have been prohibited, but the court isn't going to give it to them on their own accord. That moves us on to, so that's 1942. We have Gideon versus Wainwright, 1963. Does someone want to take this one?
Alright, so I believe this is the case that actually overturned, Betts versus Brady.
Yes.
And that here the petitioner was charged in a Florida court for robbery or breaking and entering into a pool house with intent to commit a misdemeanor. He goes on to ask them to appoint him a counsel because he's poor and doesn't have money. The court, because he's not an indigent defendant charged with a capital crime, he was not appointed one and not given even the right to ask for one, even though he had. So he goes on to defend himself in the trial court. He tries to put on the best, basically tries to be his own best advocate, fails at it, and so he appeals and takes it up to the Supreme Court, who I believe says that because going to court is right here. The way I saw it was this: a provision of the bill, the rights of the fundamental and essential. They're fundamental and essential to a fair trial and made obligatory upon the states of the 14th Amendment, basically saying that the 6th Amendment did, through the 14th Amendment, offer or give this man the right to ask for one and be appointed to one through the courts.
Right.
He didn't have to be an indigent defendant to be charged with capital crime to get that assistance from the court.
Right.
That's what I got from.
Yeah, so like I said, the opposite of the case before.
Yes.
I see the court again talking about that kind of selective incorporation, except here they're saying, yes, this is only coming in now. The 6th Amendment is applicable via the 14th Amendment. Everyone's got the right to counsel, and so that's how we have the right to counsel now. That's how I have a job in the public defender's office because of essentially this case. 1963 is not that long ago, so 54, 55 years, 56 years ago. So that's really nothing. Like most of us, that's our grandparents' time, right? Me, well, it's a little before our parents' time, but like at the time our grandparents are probably our age. That's very, very recent. So you can imagine the amount of scrambling that various municipalities and governments had to do at that time to put this stuff into place, right? So this comes down in 63, there's nothing in existence at the time. There's not even a public defender's office on standby. It's just all of a sudden we know we can't prosecute cases unless everyone's given an attorney if they can't afford one. So
You can just see everybody raise havoc over this. Like,
yeah, I can imagine the amount of
everybody's gonna get out free.
the amount of panic that had been going on, at the county
In both
level,
areas.
state level, about the need to kind of create this system. The court gives a little bit of some of the reasoning behind it. They talk about how much the government spends on attorneys in order to protect public interest. Essentially pointing out anytime anybody does have the money to hire an attorney, they always do so. And basically pointing out, like, look, even the government thinks that they need an attorney. The government's not just sending in a random person. People can afford to do it. Everybody thinks that they need this. It's not a luxury item. That's kind of how it was viewed previously. It's just something that everyone needs. It's a standard.
You couldn't have a fair trial without them.
Yeah.
Basically.
So you get the concurrence. Their main issue is they don't. A lot of times you see justices, they don't like to break from precedent very much, not easily without really good reasoning. They feel like they could have brought in some more of kept some of the old language instead of just whole incorporation, just treat it more like capital cases. but that really doesn't change what things were. You know, they're still kind of, even capital cases for the most part, they're just kind of presuming prejudice. They're still kind of taking things kind of case by case, and said yes, absolutely in every case, although they were treating it that way. So I don't know how workable that is if you're just going to start treating every case like a capital case. You're just kind of paying lip service to your prior rule without actually applying it at that point. So 18 USCA 3006A required the feds to set up a deliberate system for adjudicative defense. Most of the jurisdictions opted for public defender offices at the state level. Local governments decide what deliberate system is used. It's done primarily at the county level. We talked about this a little bit last time. Like out here, we have the public defender's office. We'll have a conflict panel for some of the cases the public defender can't take on. You might just have exclusively like a criminal defense panel in some smaller counties. You see this primarily on the counties that are bordering California and Oregon at the north end, so not so populous, or those along the eastern Sierra side, and then other places like LA, they'll have multiple layers of different unaffiliated public defender's office plus a conflict panel. Note 4 talked about a system that was being explored in Texas, the idea of a voucher program, where you basically give a voucher to a criminal defendant, they can take it to a private defense attorney, and the court would essentially pay that attorney. What do you guys think of that? Interesting, right? So I guess it's going to depend. I mean, yeah, I could see that is an interesting approach, but I can see that very quickly leading to some attorneys being overwhelmed compared to others. If they're not, I don't know, some attorneys naturally charge more, so I don't know if that means that people on the low end would get to charge more because that's what the court voucher allows, or people on the high end are potentially just looking at taking less, or if they're taking a court voucher plus requiring a little bit more. It's an interesting idea. There's a lot of criticism nowadays about lack of funding in indigent defense, the amount of time that individuals have to prepare on cases. There's still a lot of criticism about the disparity between the amount of funding between like a district attorney's office and public defender's office. I don't know if that's how likely that is to change with time, really. I mean, it's just one of those, it's more like a political thing, I think, at a certain point. It's always popular for politicians to be taking a stance of being tough on crime, or to be making your streets safe and pumping money into law enforcement or into the DA's office. But it's not necessarily the most popular thing to say, hey, we need to be, supporting the criminal defense side of things. It doesn't make sense. They're protecting everyone's rights. If the defense bar is weak, then you might start seeing things like more and more emboldened police activity, or even unintentional things like maybe sloppy police activity. They get trained wrong. They might be stopping people with less than probable cause, or intruding people's rights, or getting warrants that maybe shouldn't be granted. And then the courts just get used to doing these things, and then you might have a problem. Whereas if you have a very, very active defense bar and challenging more of these things, you're more likely to hold them to the letter of the law, which is really better for the whole community, but it's still not very popular from a political point of view. So I don't know if that's likely to change over time, but it's just the way things have been for as long as I can remember. It's concept of indigency. So local legislature and courts are going to determine what this is, and it varies jurisdiction to jurisdiction. I find it even varies from judge to judge. A lot of times, I remember when I started, it used to be judges would just come in and basically ask somebody, hey, do you have an attorney? No. Can you afford one? no, okay, you get the public defender's office, and that was it. Then I'd be helping somebody out, the next minute I'm seeing them drive off in a brand new Mercedes, and I think, what are we doing here? You never know what, it could be their parents' car, it could be leased, whatever, but it still felt weird. And there's other judges on the other end of the spectrum, you start seeing they'll have worksheets that were generated by the courts that have a spreadsheet of assets and income and expenses to really try and evaluate whether it's appropriate for an individual to get a public defender or an appointed attorney or not. So it just kind of varies depending on the judge. You got some statutes require a defendant to pay back the county. Some of those statutes have been upheld, some have not. Generally, it's been found that it's not okay to impose these fines just because the defendant loses, but it is okay to make them a condition of probation. Let's see. All right, so we'll move on to Arsinger versus Hamlin. Anyone want to take that? Any questions so far? Just to summarize the last 25 minutes, we have one case that said that we don't have the right to appointed counsel, and then another one that says that we generally do. Now we can start finding there are limits to that.
Is that, did you see Rothergy?
Next case,
Yes, we're on.
Arsinger versus Hamlin.
Oh,
It's page 74.
okay, gotcha.
Do you want to take that one, Trish?
I did not brief that one. I didn't see it on our list. Does anybody else have that on the list?
No,
I guess we do.
not on the one you're talking about.
I mean, the only thing that came, what I got from that is that they just struck down the Florida rule, requiring counsel only for, if the punishment is greater than 6 months.
Right.
Right, I didn't see any other like facts or other explanations.
Important.
Yeah, in the book, it wasn't like a case, it was like a.
Well, it says it on the top, that it's extending Gideon to the misdemeanor cases, so I guess that's what it was
Yeah,
doing.
yeah, it says we must conclude therefore that the problems associated with misdemeanor and petty offenses often require the presence of counsel to ensure the accused a fair trial.
All right, yeah, I'll take it back. I'll pick up with Roth, Gary, and I'll handle some of these. I forget that some of these are just limited to the point where they're not going to have much in the way of facts. So we start with our precursor case of Zerbst, federal government. Everybody gets the right to appointed counsel. Then we move on to Gideon. So now we know that we have the right to appointed counsel in felony cases. Arsinger, again, we're allowing it in misdemeanor cases. So Florida law says basically anytime punishment can exceed 6 months. Yeah, so Florida has law, you can only have getting too confused. That's where I'm gonna trip up. Okay. So Florida had this law that basically said on misdemeanor cases, if the punishment can't exceed 6 months, then you don't have the right to an attorney. The court struck that down. It's likely that Florida got this law came up with this law because you have a similar kind of situation where you're dealing with the right to a jury trial. So if you have, if you're denied the right to a jury trial, you can only be in prison for up to, I think it's up to 6 months. I think it mirrors that. The court said that's not okay. I think it's because some of the convictions that you can get in misdemeanor land, right, can be different than just the amount of time that you serve, right? So they say it's not as big a deal with the jury trial issue if you're not doing as much time, but the result of the misdemeanor conviction can last a lot longer. Some key examples: DUI. If there's a lot of places you're trying to apply for a job, will not even look at you if you've got a DUI, especially anything that involves driving. But more and more, a lot of employers just don't like that. So you might not stand a chance. Domestic violence, for example, certainly carries a lot of weight. Resisting an officer is going to label somebody, and it's going to affect how police approach an individual. And that's before you even get to things like an indecent exposure type of case, where you might end up being a sex offender for the rest of your life. So they basically find that it's different. The concept of having a jury or not is different than having an actual attorney represent you to deal with the complexities of trial, and that's how they separated the two. The concurrence wanted to treat misdemeanors more like the old felony system, where, hey, let's look at this on a case-by-case basis. That would have addressed some of these issues of the more serious consequences that you can have on certain types of misdemeanor cases, and not overburden the courts with every single run-of-the-mill, like drunk in public, trespassing case, and would have struck a better balance. Because you can imagine in their minds, they're trying to think about how much is this going to cost? What are the logistics behind this? Because somebody's got to structure this, somebody's got to deal with all of these cases. So that's probably why they were a little bit hesitant.
That's actually what I was gonna ask you. This is more about state funds and crowding the courts and stuff, almost more than it is constitutional rights. It seems like even, they're taking that into more consideration because
It's competing interests,
Yeah.
right? So they're trying to figure out what's going to work. And I'm sure that's probably what was in Florida legislature's mind is, what do we do here? At this point, there's not really clear law. I mean, there kind of is. They said, the Sixth Amendment's going to be incorporated, it's going to be wholly applicable, but then they're kind of saying, like, really? Because maybe, all of these things, let's see if we can get away with maybe less than that, and the court says no. We have Scott versus Illinois, which tells us that just how far this goes. Defendant's charged with shoplifting, punishment could include fines and imprisonment. He's not given counsel. And on conviction, he's not given jail time either. Here, the Supreme Court found that this is okay, so they drew a line at actual imprisonment. It's different than a fine. Since the defendant didn't go to jail, the Sixth Amendment and 14th Amendment were not offended. Concurrence is concerned, judge might tie his hands in advance at trial, limiting sentence options before he knew what the facts really were. Also concerned about corollary that non-custodial punishments are more serious than jail. Some of the things we just talked about a moment ago, those aren't really addressed by this particular rule. The dissent was just taking the opposite approach, that our standard was clear. If the possible punishment can exceed 6 months or incarceration is likely, an attorney is required. And they're again pointing out that effect is not petty and carries a social stigma. It's a whole lot less of an issue in California right now. A few years ago, they really got rid of imprisonment on all infractionary cases. So things like speeding tickets, like a low-level disturbing the peace. People can't really be sent to jail for that kind of thing anymore. So that's why you don't have the right to appointed counsel. In a traffic matter, you're still free to hire your own attorney if you want, but you're not going to get one from the court. In practice, most states tend to just appoint counsel if jail is a possibility. It's the case in California. For example, we get family law contempt cases. I've had this situation before, and it started off the public defender's office as misdemeanors. One of the weird things that we got is family law contempt. These can be things like somebody who's not paying their child support on time, so you'll have the I can't remember if it's DPSS or CPS or one of these agencies.
DCSS.
What's that?
DCSS, is that what you're talking about?
Yeah, one of these agencies. It's been a while, but they get involved and they actually will go in and prosecute. Most of the time, they just want you to play ball, right? Like if a guy can make payments, have him make some payments, continue the case a couple times when he sees making a good faith effort, and then contempt usually goes away. But every once in a while, we get a privately prosecuted contempt case, where the other side has a family law attorney who feels that the opposing party was not following, either like alimony payment order or not complying with custody arrangements pursuant to family law court order, and they would prosecute these as well. And it seemed to be pretty common. Those cases weren't common to come up, but when they did come up, it did seem like the courts would typically deny that jury trial right to limit the amount of incarceration, which would have the effect of limiting the amount of incarceration an individual would get at a time, which I kind of liked, because bench trials generally feel a little bit less stressful than a jury trial, especially if you feel like you got a good argument on the law that I would typically want a jury or want a judge over a jury. Factual issues, sometimes I think judges, due to their years of experience, are a little bit more skeptical, so then I kind of like the juries. But legal issues, I kind of like having the judge and reminding the judge in a family law contempt that, hey, it's quasi-criminal, it's still got to be beyond reasonable doubt, and arguing any ambiguities in the underlying orders and get a long way there. Let's see. Nichols versus U.S. Misdemeanor conviction obtained without counsel can still be used as an enhancement to increase punishment on subsequent cases. So again, we're kind of exploring that limit of counsel. So so here, underlying case, individual doesn't get an attorney appointed. He gets a low offense, they don't get actual imprisonment, but then later on, they get another case where they are given counsel, then they get convicted, and now they're getting essentially more time from that underlying conviction where they didn't get any time. And now they're trying to say, hey, that's not cool, right? You can't say, well, I didn't get any time there, so therefore, it's not a big deal that I didn't get an attorney, but now they're using that to give me more time here. And the court's saying that's okay. And they're not really punishing him. He's not getting time for the original case, and it's more that he's done something in addition to that. They're punishing more severely on the current case compared to the prior one. You got the dissents basically arguing, what's the real difference here? If you're giving him more time because he had this other thing, you're still getting him some time because of that, and they're not really cool with it. We'll move on to Alabama versus Shelton. Defendant's convicted without counsel and is given 30 days suspended in probation, right? So here he gets convicted and he doesn't get any time, so he's not incarcerated. So they're thinking that they're in compliance. They're thinking that they're in compliance with Scott versus Illinois because they don't give this guy any initial time, but later he violates. The court notes that punishment and a violation is punishment for the underlying offense. So having a hearing later on, so basically he violates probation. You have a violation of probation, you can have a hearing to determine whether or not you violated. They give him an attorney here. The court says that's still not good enough. He didn't have an attorney at the underlying conviction. That's when the sentence was imposed. So it's not okay just to give him an attorney at the VOP stage. So it gets overturned. So summarize. You have the right to an appointed counsel if you can't afford it at the federal level. You have it at the state level for felonies. You have it for misdemeanors. If you get actual time, you don't have it. If you don't get, if no time is imposed, so you can't, basically, they don't give you any time at all. They can't give you any time if you don't get an attorney. And they can't suspend time if you don't have an attorney, because it's the same as them giving you time. Any questions about what we've covered?
Okay, so to clarify, if they don't give you time, you don't need an attorney.
Right.
Okay.
On petty offenses.
Yes, on petty offenses.
felony, yeah, you're still gonna get an attorney, because I think with the felony case, you know, you can always get sentenced on a felony case, there's always time that's kind of hanging over your head. So we've talked about some situations in which one will get an appointed attorney. The next section covers at what point this right attaches. So when is that right? When do you get it? So Tricia said you want to take Roth Gary versus Gillespie.
Sure, I can do that. So, one second. So basically, the case involves the issue of at what point in the criminal proceedings does the right to counsel attach, and they also discussed what are the critical stages in the criminal proceedings. So the facts are that Mr. Rothagery was arrested in Texas as a felon in possession of a firearm. He was taken before a judge, and upon learning that seeking legal assistance would delay the proceedings, he waived his Sixth Amendment right to counsel. Also, no prosecutor was present at that hearing. He posted bail and was released, but was rearrested after a grand jury indictment several months later, hiked his bail to I think it was $15,000. Throughout the entire period, Rothagery continued to pursue his legal counsel, but only got it 1 week after the grand jury indictment. His attorney produced evidence that he was not, in fact, a felon. He was actually released from custody at that point. Rothagery brought suit against Gillespie County, Texas, for violating his civil rights by not appointing counsel. Both the district court and the Fifth Circuit rejected his claim. The Fifth Circuit stated that his Sixth Amendment rights were not implicated because no prosecutor was present at the initial hearing. So the issue that I had was, did the Fifth Circuit err in holding that Rothagery's rights to counsel under the Sixth Amendment was not implicated when he was denied counsel at the time of his initial hearing for being a felon, but the hearing was conducted without the involvement of a prosecutor. And the Supreme Court ruled 8-1, yes, the court held that a criminal defendant's initial appearance before a judge marks the beginning of the proceedings against him and triggers the defendant's Sixth Amendment right to counsel, whether or not the prosecutor is aware of or involved in that appearance. The dissent, Judge Thomas was the lone dissent judge, saying that the Sixth Amendment offers strong evidence that the term criminal prosecution refers to the commencement of a criminal suit by actually filing formal charges in a court, and therefore the defendant's initial appearance before the magistrate did not commence a criminal prosecution, as no formal charges were filed at that time. Also discussed in the case was two things that have to happen in order for the defendant to be appointed counsel. One, there must be a criminal prosecution, meaning that the adversarial judicial criminal proceedings must have commenced in some format. And also they discussed the counsel must be appointed within a reasonable time, and the defendant is only entitled to counsel appointment in critical stage of the proceedings, which in the discussion ends up being what is reasonable. And that's what I got.
Oh, how do you guys feel about this case? This case is a tough one because of how it's set up. When does the right attack, right? Sixth Amendment right to trigger. Prosecution commences, but it's not really a formal indictment. It's when the defendant organized. Later cases they'll talk about that kind of lets us know, right? So when this person finds himself in an adversarial setting, when they're facing off against he must be an attorney within a reasonable amount of time, and then he has, so that's part of it, that's one part. The other part is that he has a right to an attorney at all critical stages, and that's where this gets a little bit confusing. So if you're talking about a probable cause hearing, what we might commonly call a Gerstein review hearing, right? Someone's been arrested, somebody has to make a determination whether or not that there's probable cause to believe this individual committed crime in order to hold him in custody. Right? So typically that's not considered a critical stage in and of itself, so that an attorney has to be there at that probable cause to hold somebody in custody stage. But they're saying within a reasonable amount of time, they're saying 6 months is a bit too far, somebody needs to be given an attorney, right? They're not in custody, they're not free to go. That feels pretty adversarial. So no, he doesn't get an attorney at that stage, but he should be given an attorney within a reasonable amount of time. That's where this gets really confusing. So just remember, using kind of common language, right? So when a person finds himself squaring off against the powers of the state, they should be given an attorney within a reasonable amount of time, and they have a right to that attorney at all critical stages. Right? It's an easy way to narrow this case down into just basically 2 bullet points. That's one thing to note in the concurrence, kind of drag it home a little bit. There's a difference between when the right attaches and the time at which an attorney is required to be present. Here, that's kind of fits squarely with this kind of notion that the court is struggling with. We know that they're not required at this kind of Gerstein review stage, but they're saying it should be given them a right within a reasonable amount of time afterwards. Another problem we come across this problem from time to time in the law, hopefully not too often. They don't state a remedy. What's to happen to this poor guy, all right? We don't give an attorney a reasonable amount of time, he sits in jail. That's wrong, but what's the remedy at this point? The case is resolved. This attorney showed he wasn't a felon, therefore he can't be found in possession of a firearm. He's out, he's done. With somebody at an earlier stage, what happens to them, right? If their case is still ongoing, do they just get let out of custody while it's ongoing? Does the case get dismissed? So at this point, the court did give a remedy. Remedy, what do we do? So we can acknowledge, right, there's a problem here. So then the courts just make sure that now we give them an attorney to speed the process up. But if the person's been waiting an undue amount of time, that's of little effect to them. Page 84, note 3 gives us a list of some of the different situations in which are considered critical stages, some that are not considered critical. Plea negotiations, it's Lackland versus Cooper, we're going to cover that case later on. So you can't have a random court date, attorney calls in sick, district attorney's like, I'd really like to make this case go away, it's been on my desk for a while, I'm just going to go over and talk to the defendant and work it out. That's not okay. Pretrial ID, U.S. versus Wade. So this is an in-person show up, right? You want to bring 6 people in front of the wall and have one step forward, give a voice sample, that type of thing. That's not okay. But photo ID, 6-pack photo lineup, that's fine. You don't have to have an attorney for that. Police questioning, they have the right, that can be waived. Certain arraignments, when they're going to be concurrent with like a bail review argument, typically here we kind of combine the 2 of them, so we'll have an attorney present, we'll make our initial bail review, which is kind of like wrapping up that kind of Gerstein probable cause review within that as well. So the way that we do things locally, we kind of have the benefit of an attorney at that point, even though you're not necessarily entitled to an attorney for that probable cause review, because we do it in arraignment. By default here, we get that attorney. And preliminary hearings, those shortcut, as we talked about last time, the grand jury process. So it's kind of an opposite. The grand jury, you're not going to get the right to an attorney through that process. But in a preliminary hearing done in front of a court where those exist, it is considered a critical stage. Does anybody have any questions about a preliminary hearing? Covered those a little bit last time. Yeah, everyone knows what that is. So those hearings are important here because they set the stage for trial. They can make negotiations better or worse. So if you can imagine, if you have the right to an attorney in a plea stage, then it's all the more important to have them at a preliminary hearing stage where you might have witnesses come in, you might have live witnesses come in. If you start testifying about stuff that's not relevant, or officers start testifying about evidence that was obtained illegally, if you don't have an attorney, that's going to be a problem. So that's why that right is there. Estelle versus Smith, right to consult with the counsel prior to submitting to a pretrial psychiatric exam. Court doesn't really give an answer about whether that counsel has the right to be there during the exam. So they talk about ahead of time, the defendant can talk with counsel about what's going to go on with the process, maybe what types of things to talk about, what kind of things to stay away from, but they don't necessarily have to have the right to be there during the exam itself. Imagine this is probably more of a situation where you have somebody who's running like a not guilty by reason of insanity defense, and you have a district attorney who's hired their own doctor to try and evaluate the defendant to see if they can have their own expert to challenge the claims raised by the defense. I've not really had to deal with that issue personally. The closest I've had is probably when I'm dealing with a client that's not potentially not competent to stand trial. We'll get a doctor appointed to talk to them to try and see whether or not they're competent. And I can try and talk to my clients to let them know what to expect, although generally those clients aren't necessarily probably aren't understanding much of the conversation at that point. But my experience has largely been that the doctor does not want me there because it interferes with their ability to give a full assessment of the defendant. Someone want to take on Gagnon versus Scarpelli? Following page 86.
Okay. So on this one, the defendant pled guilty to armed robbery. He was sentenced to 15 years in prison. However, in his sentencing, he was suspended and he was placed on probation. And then a month later, he was apprehended for burglarizing a home, and then so probation was revoked. And they said that on this, it was on two grounds. One, Scarpelli had associated with known criminals in violation of probation, and while associating with the known criminals, he had been involved in the burglary. So then the court discussed Mempa v. Ray, and they said that typically the court held that a probationer, they are entitled to counsel when there's a revocation and sentencing hearing. But in this case, I'm not sure if it was this case, but there was a distinction that it does not require a hearing or counsel at the time of probation or revocation if that was done at the time of trial. So then they said that the Gideon and Argensinger didn't extend to that, because it was done at the time of trial. But I was a little confused because this would have been done after, not at the time of trial.
The distinction they're trying to draw here is has to do with the suspended sentence.
Okay.
So here we have a situation where they had a sentencing hearing, and the court saying sentencing hearing is a critical stage. This is because you'll have attorneys that are presenting like a legal factual argument, right? Here's some information we have about the defendant, this crime, his criminal history. These are the circumstances in mitigation. He is presenting circumstances in aggravation. Both sides are going to be arguing about maybe the validity of the information that's being presented to the judge, and the judge has to make a decision. So if there's an actual sentencing hearing and attorneys are present, then at a certain point the judge might impose a sentence and suspend it. And that's like saying, this is going to happen usually post-trial. The judge puts somebody on probation. So the judge has imposed sentencing. He's made that decision. So now if the defendant violates probation, the court has two options. We can reinstate probation, or we can impose that already selected and argued out sentence that the judge has already decided.
Okay, so the issue here was that they revoked probation without giving him that trial. Okay.
Well, here he had the suspended sentence. So his probation gets revoked. He does not get appointed counsel, and the court says that this is okay. It was suspended at the critical stage. He had an attorney, but they draw a distinction where they say, look, if this guy had been given probation and no sentence had been imposed, then at a certain point they're going to have a sentencing hearing, and that is a critical stage. And in that situation, you would need to have an attorney.
Okay.
So that's So there's kind of two ways to look at it. If you have, you can look at it focusing on whether or not a sentence is suspended. And if it's suspended, don't need an attorney at the VOP stage. If it's not suspended, you do. A deeper level understanding is to point out that like sentencing is a critical stage. So if you've had that sentencing hearing and there's not a need for another one, then you don't need an attorney at the VOP stage. Does that make sense to everybody? Any questions about that
I'm a
one?
little bit confused because of the paragraph on the bottom of page 7 that talks about in trial, how you have the formal rules of evidence and all that, but in a revocation hearing, it's put on or with a parole officer and the formal rules of evidence aren't followed and all the rest of it. So I guess I'm just a little bit confused because then it seems that they go back to saying that he did need counsel. I don't know, I was pretty confused by this one. The last sentence says the need for counsel at revocation hearings derives from not from the invariable attributes of those hearings, which is what I guess I was talking about. They don't follow possibly the formal rules of evidence, but from the peculiarities of a particular case. But and the holding does say that it has to, or the rule really is that it has to be dealt with on a case by case basis. Does that make sense?
So courts kind of outline, right? There's situations where they're being asked, like, do we absolutely get a right here, right? They're saying no, there's not an inflexible right, and they're kind of describing situations where you maybe where you absolutely would, in that situation where you don't have sentencing, which is a critical stage, whereas here you have that kind of suspended sentence, so you already have the sentencing. The issue that the court appears to be having is with the VOP itself, the process in which it was done. They don't feel that that met the requirements of due process, so they're sending it back to the lower courts to make sure that that due process requirement is met in terms of how they're violating this individual. But then they're also leaving it up to the states for saying, look, it's not required in certain situations, and some of it is when it's critical and you have to redo that sentencing, and some it's not. We're not going to require it in every VOP, but we're going to leave it up to the states. If they want to add that requirement themselves, they can. They can treat it on a case-by-case basis. It might be saying to the court, like, look, if someone's looking at a ton of time, maybe the court might be more, maybe it's better for the court in that situation to have an attorney appointed. Maybe they want to actually treat that hearing a little bit more formally, right? So they're not, what they're doing is they're trying to basically say, look, we're not saying there's an absolute right here, but they don't want to at the same time tie the court's hands and saying that you can't appoint an attorney that they, that you don't have to give them one.
Okay, that makes sense.
There's a note in here suggesting the defendant might be better off without, it talks about, whether or not the defendant might be better off without an attorney. The judge might be hostile to their presence. This is really not my experience at all. Anytime someone's dealing with the VOP, having an attorney, I think, is critical. Just because even people who really haven't violated, my experience has been, they just do not know how to articulate very well. A lot of people that get swept in the criminal justice system, I think, as a whole, aren't very good at expressing themselves, and might end up saying the wrong thing or saying the right thing the wrong way, or they get really excited because they're worried they're going to go into jail, and then they start jumping around. Their statement doesn't make sense. If they're doing this in front of a judge, then the judge is going to start shutting down. Stuff's not going to sound like it's consistent. They're going to think they're lying. They're just going to violate them. So sometimes even just taking as little as like 10 minutes to just hear everything that they've said, And then just to be able to put things in the right chronological order for them is key. And then as well as highlighting all the good stuff they've done, they check with probation, stuff that the individual defendant's not gonna think to do, and the court might not take the time on its own to do. So generally, I think they're way better off to have an attorney there. I've never had a judge that's been harder on a client just because I was representing them. Some of the situations, let's talk about Lindor versus Henry. You don't have a right in summary courts martial. That's just something kind of maybe a piece of info to keep in the back of your head. Not going to test you guys on that. Let's see. No right in collateral proceedings like habeas corpus, in re galt, juvenile delinquency proceedings, when loss of freedom is at stake, the child and parent must be notified of the child's right to an attorney. These are often comparable to adult felony cases. Child has a right to appointed counsel. Juvenile delinquency proceedings are another one of these that tentacle a little bit in a kind of a higher area of law, but very strong criminal law elements in there. No right to a jury trial, but a lot of the impacts on there can be just as severe. The court will usually make findings that the juvenile has committed a particular act, and those can have the same effect as a misdemeanor, a felony conviction, or even a strike conviction. So those are really kind of a big deal. Lassiter versus Department of Social Services, Child Custody. No automatic due process right to counsel here, determined on a case-by-case basis by state courts. So one isn't at risk of losing their individual liberty, but I don't know, I think a lot of people, especially parents, who probably view the right to raise their kids and to have custody of their kids is kind of up there with their own personal liberty right. So it's, I don't know if it's really splitting hairs to say, one, we're going to give people the right to an attorney, but on another highly impactful area of a person's life, we're not going to give them an attorney. How do you guys feel about that? No thoughts? It's Wednesday at 7, we're all kind of getting tired.
No, I don't know. The book talked a lot about civil law too, and how the ideas are being kind of thrown around for civil litigation. That's kind of what I think, because I know family law isn't just, I mean, it is civil, but it's like not, at the same time, because you're dealing with relationships that are messy and children that are taking the brunt of it. So I think, I think yes.
Yeah. In all civil or just family law?
Just family law, yeah. I think civil, then you just be opening the doors to a whole,
who knows what?
Yeah.
Well, here, like you said, you're taking somebody's kid away, and if you're gonna take their kid away for a, good reason, then if you're gonna have somebody proving that this person isn't capable of taking care of his child, well, then at least give the person a good effort, and somebody that would help them defend themselves to prove that person wrong. And like you said, a lot of the times these parents can't. A lot of the times they don't know how to defend themselves. They don't know how to state that and show that they are good parents, and that a lot of the things they're going through aren't really their fault. So I 100% think they should be appointed.
I mean, it seems to make more sense, especially if you're dealing with like a state-initiated proceedings, right? Where it's maybe DPSS is taking away somebody's kids. You have somebody who does this all the time. They're used to building these cases. They know what to show. Whereas maybe it makes a little bit less sense if it's like, one parent going up against another parent. That income disparity might make that situation really unfair as well.
At the very least, I think there should be more resources, like we work at the inland
Yeah, legally, yeah, I see.
I think there should be at least more resources, because you see a lot of pro per in civil litigation, and people don't really know that they have these resources.
No, they don't, you're right.
Yeah, I think at the very least, they should be
And we
more.
can't take criminal cases.
Yeah.
We cannot. But yeah, you're right. A lot of people don't know.
Maybe even just a minimal, like an education broadcasting service might help with some of that as well.
Especially without backed up the calendar is, and now there's only, what, 3 of them that sit and do FEMA here in India. There's 2 of them in commissioner.
Oh yeah, but they're busy.
They're busy.
I think they're open busy.
They're really busy.
I think they're up for, they used to only have 2, so they're kind of up from last I checked in on, but I don't usually try to go anywhere near if I know what court if I could avoid it.
So no, me either. I only get the updates from the NCOs we have here every year. Let's see.
Oh,
So Turners versus Roger, dealt with the civil contempt hearings, defending sentenced to 12 months of custody for failing to pay child support, no automatic due process right, and basically saying here the court can impose its own safeguards to ensure fairness, especially when the custodial parent is not represented by counsel either. But here they found a 14th Amendment violation because no according to defendant's ability to pay. I'm kind of surprised that they allowed an individual to be sentenced 12 months of custody because it seems to run afoul of some of those earlier cases that we talked about. That's what they did. Timeline's really good. So Griffin versus Illinois. Somebody want to take on Griffin versus Illinois?
didn't read that one.
Yeah, I guess.
Yep. Is this one of the shorter ones?
It is one of the
Okay, so in this one, it was, the issue of whether it should have counsel for, the appellate level. And, at the appellate level, you're required to have the transcript, and you couldn't have a hearing without one. And before, they only issued the transcript to indigent people for death penalty cases. And here the court said basically that the ability to cost has no bearing on whether they're guilty or innocent. So if they do, grant the appellate proceeding, then it should have counsel. But I believe it was only if they granted. Is that correct? Yes.
So one of the key things when you're looking at the right to appointed counsel when you're dealing with appeals is it a automatic right to appeal or is it a discretionary right?
Mm-hmm.
So if everybody has the right to an appeal, they have the right to be able to work there effectively. So we're getting an introduction to the equality principle. The state can't discriminate against poverty. The state's not required to provide appellate review, right? So the court doesn't have to give this kind of intermediate appellate right. But if it does, if everyone's got the right to an appeal, the court has to make sure that that level is fair, right? The equality principle is dealing with kind of a equal playing field. So one of the analogies I use on bring up again and again is think of the situation of like old school medieval times, right? A king is presiding over a jousting court, right? So if the court has basically said this jousting is open to everybody, he's got to make sure that this is fair. We don't want to have the government riding in on its shiny, like armor-plated stallion over here with a trained knight, and then some guy basically like trying to saddle up a donkey with a, with a broom handle on the other side. So in that situation where everybody has the right to take the field, it's got to be equal. So that was a felony case with Mayor of Chicago, or Mayor versus Chicago. Here the appellant gets provided with sufficient record for appeal, even if the ordinance violation only results in a fine. So here they're taking that kind of concept and basically saying, look, have that automatic right to appeal. Yes, this is a low level kind of nothing case, it's just a fine, but we're still gonna give them a free copy of the record. Those things can get expensive. I don't know if anyone's dealt with ordering transcripts before. Those get pretty pricey. So here they're saying, yeah, the state's gotta foot the bill for that and cover the cost. They're not gonna do a balancing situation. The fact that the harm to the defendant is slight compared to the county is not something the court's concerned about. What they're concerned about is his ability to take that field. If it's open, they gotta allow him to do it. Here, without a record for appeal, an appellate court can't act. So the individual, they're saying, yes, the field's open, but we're not gonna let you in because you don't have a horse. You're getting the horse. Douglas versus California. So defendant denied counsel on appeal. Appellate court reviewed the lower court record, found nothing useful would come from the appointment. California procedure at the time left the appellate counsel appointment up to the court after reviewing the record. Court says this is okay. Same problems as Griffin. Basically here, the court says field's open to everybody, but the court's just kind of taking on the role of that kind of defense appellate attorney. They looked at the record, said, we don't see anything here.
Not right.
There's nothing to be litigated, and they're done. The court says that's not okay. So, whereas I get the good quote in here: "No equal justice or the kind of appeal a man enjoys depends on the amount of money that he has. Why should the court get to decide whether or not he's got any merit to his argument, just because he doesn't have the money to hire his own attorney?"
What I thought was funny here was the dissent saying like, no, the equal protection, even though it's like equal protection, they're like, no, that's not what it affords you. It's like,
yeah,
it does afford you that. What do you mean no? Basically in the title, even though they were trying to say that this doesn't force the state to do that, but I just thought it was funny that they were trying to say that something that basically does flat out say that your rights are protected didn't really apply here.
Yeah.
Makes sense.
Dissent was basically their issue is that they felt like they were imposing an additional duty on the states. The Constitution didn't require, right?
And they felt they didn't say that
Right.
duty, didn't impose that duty.
Right. This goes back, like I said, to that kind of due process analogy. There's a lot of stuff that government does that it doesn't have to do. For example, plea negotiations. The government's not required to engage in those. They can say, look, we just don't want to negotiate. We'll just go to trial. They can do that. The Constitution is not going to force them to negotiate. But if they are going to engage in that process, if the government's taking the field, then the field has to be fair. And that's what they're saying here. They're not requiring the government to take the field at all. The government did that when they basically said, look, everybody gets this right to an appeal. But they're saying you can't say everyone has the right, but then the poor people don't get to present an argument. The court reviews it and determines whether or not they get it on their own. That's not okay. That's not the government acting fairly. So, someone want to take on Ross versus Moffitt?
Yeah, I'll take them. Okay. So in Ross, it was the individual charged was an indigent, and he was provided counsel in both the trial stage and the appeal stage. He was convicted in both. However, and moving forward towards the discretionary review or superior court, he was denied counsel. So that's the issue. Then is an indigent. The state need to provide indigent counsel at the discretionary review. The rule and the court held that they are not given that right because they gave two reasonings. They said the critical issue in the discretionary review is that the subject matter of the appeal has significant public interest, whether the cause involves legal principles of major significance to the jurisprudence of the state, or whether the decision below is in probable conflict with the decision of the Supreme Court. Further, they said that once at this stage, if the defendant's claim of error is organized and presented in a lawyer-like fashion to the Court of Appeals, the Justice of the Supreme Court, making a decision to grant or deny the review is able to ascertain whether his case satisfies the standards established by the legislature for review. So basically, it's at this point, there's really no distinction between a wealthy defendant versus an indigent because of the fact that they've already been represented at both stages, and that a brief presented to the court is sufficient enough for them to decide or make a decision. So that's pretty much it.
Yeah, it's here the same look, the field isn't open to everybody. Right. Supreme Courts, the higher appellate courts, they can take a case on a review if they want. They can choose not to do so, and they don't really have to give a reason why. They just say, no, we're not taking it. We don't think it's a sufficient interest, or it's not something that's worth our time, or not something that's proper for us to deal with. They don't seem to draw a distinction, or the court doesn't seem to really draw a distinction between the likelihood of the court taking an interest in a particular subject matter when the higher level appellate brief is, written in pencil versus one that's drafted by an attorney and it's like laser focused in on the points. But that's the way it is. They don't have to take a case. It is not an open field, so they don't have to appoint an attorney in every single case to file that appellate brief. And so it's kind of a line in the sand for the right to appointed counsel at the appellate level. In practice, I don't think that this has really turned out to be too much of a problem. My experience has been, or at least what I've seen, is that when attorneys at the appellate level feel strongly enough about a particular case, that they really feel like they've got a good argument and that they stand a good chance at making some new law, or that they're going to win in the long run, or that the issue needs to be resolved, they usually take that up on their own. I've seen that happen numerous times. They get, appellate attorneys are very passionate about what they do, and like all attorneys, they don't like losing. Most regular criminal attorneys aren't filing appeals because that's a whole different ballgame than what we're used to. But appellate attorneys' appeal is an appeal to them. So when they feel strongly enough about it, they'll just take it all the way up themselves. So even if they're appointed at the lower level and they're not really appointed for the higher one, they're going to do it anyways because they want to win. They want that case law in their favor. They want to argue it out if the higher court is going to hear them. So it doesn't seem to have had much effect in practice of limiting those higher level appeals. All right. Kind of an oddball case in here. Halbert versus Michigan, right to counsel at first level discretionary appeals. So this is where things, a wrench kind of gets thrown in a little bit. Michigan, you have the right to appeal. The right to appeal after conviction is automatic after trial. So anytime somebody goes to trial and they lose, they have this automatic right to appeal just like anywhere else. After a plea, it's discretionary though, meaning that if somebody pleads a case out in Michigan and they want to appeal a particular issue, the appellate court can act kind of like a higher level court and may or may not take it if they don't want to. They don't have to state why. So basically, of course, trying to figure out what's going to control here. The Douglas right to counsel at first level appeals, or Ross's no right on discretionary level appeals. The court errs apparently on the side of cautions given a right to counsel. Of course.
Well, they side with Douglas, but then they kind of state, like you said, they give it like an iffy type of thing, right?
Yeah.
They don't really, they say, yes, you can have a right to counsel, but that's the part I got confused on. Because they do say they give you a right to counsel, and they pick Douglas, which Douglas was the one that you said a little while ago, the indigent, right? So the indigent defendant, he requested the assistance, and they didn't, at first they didn't give it to me because the appellate court reviewed the case. That's the one you just told us. They reviewed the case, and then they said, nah, nothing would have changed if we would have given you a counsel.
Well, they give them a right to counsel here, yeah?
Yeah? Maybe that's because I saw them say Douglas, but then I was like, well, why are you right here at the end? It was court cases framed by 2 prior decisions of the court should be certain to the language of the decision should be the instant case be aligned. No, you're right. We hold that Douglas private controlling instruction 2 aspects of Michigan Court of Appeals processing. So basically, they just upheld Douglas, said yes, doesn't matter. You still need it because you still need to fight your way through it. You still need to represent your case in the best possible way, and only an attorney can do it.
Right, so they're kind of highlighting some of the situations. One of the other differences between that kind of discretionary appeal between a mid-level appeal and a higher appeals court and the situation here, right? When you have that mid-level appeal, an issue has been fully briefed, right? On a mandatory appeal, they've given an attorney, a record is kind of generated, put together, you have that packet of everything that went down, you have an attorney that reviews it, basically says this is what the issues are. And then if they're not successful and they want to petition to the higher court, some of the reasoning behind the Ross decision is, look, this guy's already got this packet together, right? So an attorney has prepared something at this point. And that can go up to the Supreme Court for them to kind of review, even if they don't have an attorney to make that additional appeal. They kind of have an idea of what the issues are, because the issues at that highest level appeals court are not going to be different than what they were at that mid-level appeals court. They have to be the same issues. You can't raise an issue at a second level appeal that you didn't raise on the first level. Here, you have somebody that doesn't have that, right? Just like that first level appeal, because that's what this is, although it's discretionary, there's nobody to put together that record, there's nobody to frame the arguments. And here they're basically saying, look, it's just, you should give them an attorney here.
So that they can do that.
Right, the reasoning behind Ross isn't as strong here, and you're gonna have really messy, is the more practical argument, you're gonna have really messy records if you don't do this. You wanna have an attorney review it, they can determine if there's arguments, if so they can raise them, if not, you can have an attorney that states there's no arguments. And the cost isn't so exceptional that it's gonna cause problems here. And then you have a very strong dissent that says, look, it's not required, it's discretionary, you should get it.
It does feel a little bit like Daniel stated in the beginning, sometimes when they make those decisions to not give them and assign them an attorney, it does feel like what he said in the beginning, where they look more at the interests of the state and monetary interests versus can we do good by this person? Let's really make sure this person did something before we throw them in jail. It looks like more like, this is a waste of time.
I think that specter's always there, but I think the court does try and avoid it. Here, they're just trying to make it as more like a common sense argument. But you'll notice, like we talked about in that first kind of appellate case, or the second one we came across, Mayor versus Chicago, they're kind of explicitly rejecting that kind of balancing argument of cost versus detriment, right? It's just a fine, right? If you're going to spend more money than this guy's going to pay, and the fine if he loses just preparing this record, it's not something the court's talking about. It's still concerned about their ability to act fairly. So that's why you have such a strong dissent here. This doesn't fit squarely with the prior cases, because they're saying field isn't open to everybody here. But the court's still saying it should be required. I'm saying we're moving a lot faster than we should be. Maybe we can try and summarize this. Everyone follow along with Lisa Farmer? So just kind of run through them real quick. Gideon versus Wainwright. We have the right to appointed counsel on state cases. Argersinger, this is applying it to misdemeanor cases. Scott versus Illinois. You don't need that attorney when there's no imprisonment involved. Nichols, kind of extending the Scott decision a little bit further. So if you don't get an attorney appointed, they can't imprison you, but they can use that unrepresented conviction for sentencing enhancement later on. Alabama versus Shelton is kind of a limit on the Scott versus Illinois case, which says basically that if you don't get that appointed counsel, you can't have jail time And that includes suspended time. That's what Shelton's doing. He's going a little bit further. So you can't say, hey, we're not gonna give you that time now, we'll give it to you later. That's not okay. Rothbury versus Gillespie, this is when the right to counsel attaches. So when you have a situation where you're facing down the government, you should be, that's when the right attaches, you should be given an attorney within a reasonable amount of time. And that attorney should be present at all critical stages, with a summary on page 84, note 3, which gives us a list of what some of those are. Gagnon versus Scarpelli kind of outlines when you should and shouldn't get an attorney on probation, parole, revocation settings. So if there's a suspended sentence, then you can get away without it, as long as you're following due process requirements. With a strong suggestion that the court should look at it maybe on a case-by-case basis. If there's no suspended sentence, then you're going to lead to a sentencing hearing. So then you're going to have a critical stage, and you're going to need to have an attorney. So the non-criminal proceedings in adult, juvenile delinquency proceedings, when you're at risk of losing your freedom, you get an attorney. Child custody, no. Civil contempt hearings, no. Appellate level, Griffin versus Illinois, yes, including minor cases, that's Mayor versus Chicago, Douglas versus California. It's not really any different than the prior case. That's still just Griffin versus Illinois. You have the right to appellate counsel on appeal when it's mandatory. Ross versus Moffitt, no right to an attorney on discretionary appeals. And then Howard versus Michigan, a right to counsel at first level discretionary appeals. Narrows down pretty quickly. Right, makes it nice and easy. All right. Any questions about anything we've covered so far today? That means I haven't stepped on my own tongue too many times today. So, I think we could probably go and take a break because we're moving very quickly tonight. The email handout make it a little easier to follow along?
Yeah.
Okay, that makes sense. All right, take a break, we'll come back, and we'll start up with Florida versus California. Once you get that right to an attorney, what better way than to throw it out the window, right?
Swing
Swing it.
it. To be honest, I didn't realize a lot of these cases were under notes and questions.
What's that?
So I didn't notice there were so many cases under notes and questions. I think you're right. I have it back. You can see I was actually looking at it. I did one. I think you're right. But I have it now. But yeah, you're right. It would be, it either be you, me, or something, or me.
Professor, I'm going to be there next week, so I mean, it's a little hard to hear the class. I don't know if it's just because of my computer or just whatever, but I don't know if you already addressed this. Do you have a list of cases that you want us to brief, or how do you normally handle that?
So just know everything that's in the reading Don't go beyond what's in the reading unless you really want to. You don't have to. So if there's a case that just a lot of facts, if you just know kind of what the rule is, that would be enough to just like hey, look at that, quick one-off rule. It didn't give us any facts. That's fine.
You know what? I totally did not get that. Did you say like the rule and the
Yeah, like some of
the
these
reason
are
it's in the kind of the reason it's in the book?
right. Yeah,
Okay.
Yeah, it doesn't have to be a full briefing if the case.
Okay.
Okay.
Okay, great. Thank you.
Because it's a little bit cumbersome for me. I think let's just come up with a list because then I think that that's all that people are going to do is just read those specific cases. I think it's good to at least read them on your own instead of me just running through them real quick.
Okay, cool. Yeah, thank you.
Did you see Virgil's email?
Yeah, it's kind of funny. He was talking to
Didn't we say that? Weren't we like, well, it had nothing to do with it.
That's not the doctrine, it's just dual sovereignty.
Which is all I addressed, but
Which is like, wait, what did you say again? Dual sovereignty?
yeah, he said that the doctrine of dual sovereignty. Remember we talked about it yesterday, it was you and I, right? That we said it had to do with criminal cases and then.
Yeah. What is dual sovereignty?
Dual sovereignty is the two systems of government. Dual, what is dual?
Right.
What is sovereign?
Which state the federal right? Does that mean
Yeah,
sovereignty
which means that
is-
they by themselves. Sovereign means that you govern your own yourself.
Yeah.
So dual sovereign, we have two governments that
Okay.
control themselves. Or not that govern,
Okay.
you know.
I was making sure I was like, okay, I'm on the right path because when
Yeah.
you said that too, that just totally flipped around my knowledge.
You know what I didn't do in my thing though? I didn't address the he was like, you haven't addressed, I didn't address what court he should file at because I didn't know which, like, I wasn't too like,
Oh, because majority
because
trial.
it's like, you can do it in the federal court,
Yeah.
or you can do it, but the cons and the pros,
Basically, you're curious.
yeah, it's
I
like,
said more local, which they're probably more sympathetic.
that was my thing, it was like, I didn't really have a lot of pros and cons, he was like, you have to give them the pros and cons. I really didn't see other than that, like, oh, just do it in your local because it's right there instead of having to number one, travel. I, you know, and
Yeah.
I was like, the only thing that's good is the fact,
It's just multiple.
yeah, and if you do it,
Multiple owners, so.
I was just like, but what, there's not really pros and cons to it because there's not really a big, because what's bringing them in is diversity, not an actual question that would rely on you actually having to file in a federal courtroom. I was like,
Other than the fact that maybe you're like, I don't even know, like it's more fair. I mean, the law is the same, state law, which is negligence, tort law, and federal procedures the same. So it's not.
well, that's why when I was looking at
Yeah.
it, because I took out my civil procedure outline, and I was like, well, procedurally, I guess maybe one you have 30 days, the other one you have 21 days to
Mhm.
serve, things like that.
Yeah.
Very little different, but rule 12.
Yeah.
But we have what is it, rule like 11 or something like that in California, some shit like that.
Is it 11? I can't remember.
So, I mean, you kind of,
I just skipped all the games. I was like, what am I going to
weren't you
say?
like valedictorian or something of your class? Holy shit.
No, weird. The weather's cooling down, huh? You felt it?
Yeah, I'm trying to read.
I'm so excited.
Hi, how are you?
Hi, how are you?
Doing well, thank you. All right, I think we're 72 now.
Oh, where's Trish? I'll help Daniel.
There's Trish. All right.
I've gotten the progress, like I see it passing.
So, all right, so Trish asked two things before we get going. Trish asked a question right at the start of the break, which is which cases do I brief and which cases do I not? You guys are third year. I'm not going to be collecting any formal written briefs from anybody. I've never done that. It's not really my style. I will call on you guys to talk about cases. I don't expect you to read anything beyond what's in the book. So, you know, if I call on you to talk about a case and there's not a lot of information there, you are responsible for reading everything that's in the reading. So if it's just one of those cases where there's not a lot there, just stand up and just tell me what you got out of the case. All right. I don't expect you to know facts if there weren't facts there in the book. I don't want to tell you, hey, just brief just these cases. I think it just invites too much of a danger. People just reading just those cases or focusing on those cases. And then it's really hard for me to kind of select those individual cases out of the book. Even in the index, like some of them will be in bold, some caps bold. And then sometimes some of those cases are longer. It's just not consistent with that kind of designation. So if I ask you to just talk about a case, if it's just one where it's like, oh, it's a little one, or I'd rather just talk about a big one, that's fine. But don't worry about like doing individualized paper briefs. I'm not going to collect those. If it works for you and that's what you do it, awesome. I expect most people probably take their own notes, summarize cases, and a lot of what you have probably looks similar to what I have, just in your own way. That's cool, but I don't expect like a formal written brief to be turned in. Okay, cool. All right. The other issue was, since someone asked some questions about Gagnon versus Scarpelli, and it caused me to kind of doubt myself in my prior assessment of case. I want to go back through and just review it just to make sure that my initial assessment was correct. This is kind of it's weird, and they're kind of like, they're being asked, like, right, do we have a guaranteed right to counsel in this particular probation revocation setting? The court does that distinction between suspended sentence, non-suspended sentence, because a non-suspended sentence will likely turn into an inevitable hybrid VOP hearing and sentencing hearing, and sentencing hearing being a critical stage.
VOP being violation of probation?
Yeah, right. Violation of probation, violation of parole. But what they're saying is, like, look, we're not going to make it automatic in every case. I'm
Not trying to be a smarty pants, I'm just not trying not to assume.
No. 87, the fourth paragraph down. They say, we do not draw from Gideon and Argersinger the conclusion that a case-by-case approach to furnishing counsel is necessarily inadequate to protect constitutional rights, right? So it's saying, look, you're not guaranteed the right to counsel just because it's a VOP setting. And the corollary is, they're not saying, look, we got to do this case by case, but they're saying that's not going to be inadequate. The problem that they had with this individual case is that probation was revoked without a hearing. You basically get a probation officer that says that this guy was involved in a burglary and he was associated with another known criminal, and that's it. They're suspending sentence, and that's done. So you didn't necessarily need to get a counsel here, but that particular aspect, the fact that it didn't really have a hearing here, that is a due process issue, not a Sixth Amendment issue, right to counsel issue. So that was the problem that they had.
And that's why they found he needed it, but it wasn't right.
Right, that's why they're still kind of sending it back, saying, hey, look at this opinion. They're encouraging the court to kind of take a case-by-case approach, given the complexity of particular violation of probation hearings, complex factual scenarios, complex legal scenarios that can sometimes arise. So they're saying maybe you should consider these things, but they're not saying that, that they have to, and they're certainly not saying that there's a per se rule that every time there's a violation of probation that they're going to get an answer. Now that I've made that more confusing than where I left off, we can move on to Beretta. Someone want to take Beretta? I'll do it.
All right, so Beretta was charged with grand theft, and he requested that he be allowed to represent himself. The trial judge questioned his ability to be able to represent himself adequately because he only had a high school education. He didn't know the exceptions really to the hearsay rule, I think is what it was particularly. So the judge ruled that he had not made an intelligent, knowing waiver of his right to counsel. So pretty much he then appointed on his behalf a public defender to represent him, and Beretta still lost. And then the appellate court affirmed the trial court's decision. So then it went to the Supreme Court, who granted certiorari. The rule I had is the Sixth Amendment grants the accused personally the right to make his defense. The right to self-representation to make one's defense personally is thus necessarily implied by the structure of the amendment rather than the explicit language that are looking more at the structure that it's implied. That he has a right to represent himself, and if he wants to waive it, he can so choose. So the court says there's no evidence that the colonists and the framers ever doubted the right of self-representation or imagined that this right might be considered inferior to the right of assistance of counsel. The framers selected the Sixth Amendment as a form of words that necessarily implies the right of self-representation, and that's supported by centuries of history. But they do say, on the other hand, when an accused manages his own defense, he relinquishes many of the traditional benefits associated with the right of counsel for this reason. In order to represent himself, the accused must knowingly and intelligently forego these relinquished benefits. And in this case, weeks before the trial, he clearly, unequivocally declared that he wanted to represent himself and didn't want counsel, even with the trial court judge, suggesting that he do otherwise. And the record showed that he was literate, competent, and understanding, that he was voluntarily exercising, his right of free will to be able to deny counsel and represent himself. And the right is granted to the person, that I don't know how really I'm trying to phrase this. The right is granted only to him, not to anybody else that's trying to, even help him on his behalf. It's his right to refuse. So for the defendant's technical legal knowledge, that wasn't relevant to an assessment of his knowing his exercise, him exercising the right to defend himself or not. So, therefore.
So kind of bizarre that we're only, this case is only 12 years after Gideon, where people were struggling to get their own attorneys to get assistance, and then barely over a decade later, and all of a sudden you can't get rid of your attorney. Now it's just so embedded that they're saying, like, we don't even think you have the right to represent yourself. Whereas just 13 years ago, you wouldn't even be able to get an attorney if you couldn't afford one. It just wouldn't happen, short of a death penalty case. Again, if you look at this from that kind of paranoid document point of view, right, you can see why this makes sense. If you were to imagine a kind of conspiracy theory style of government that's just controlling everybody, doesn't want people speaking out, wants to make undesirable people disappear, one of the things that they might do is, arrest them, charge them with crimes that aren't true. And what better way to kind of control the individual than to put on a false proceeding, right? You go through a trial, they have an attorney, they present evidence, but you can corrupt that entire process with just a few key things. One of which might be an attorney representing the defendant when the defendant doesn't even want them. If it's a government attorney who's controlling what information comes in, who's holding back favorable evidence, who's preventing the defendant from testifying even if he wants to, so that he can't get his statements out, then it's kind of a false proceeding at that point. You can still have all of the, the right to a jury trial, the right to confront and cross-examine witnesses, and all those just become hollow. It's all just a show, and you still have that danger of the government being able to just shelve anybody they want if they can't get rid of their own attorney if they don't want them. So from that point of view, it makes sense that an individual that doesn't want an attorney doesn't have to have them. But on the other hand, there is a cost, right? And the key to that, a lot of these rights don't always get along. Effective assistance of counsel does not necessarily get along very well with the right to go at your own, right? You can't raise an ineffective assistance of counsel claim if you've represented yourself, right? The court has no way of ensuring that you do a good job of defending yourself. You just have the right to do it, but there's no way to guarantee that you're going to be any good at it. The chances are probably that you're not. Even a trained attorney, I think, would have a hard time knowing that at the end of the day, what happens on them. That affects them. For me, that is probably one of the easier points of getting in trial, is that I know that I've been let off the chain, basically. Everything's been hashed out. Client's been fully advised. They know what can happen to them. They've understood and have decided to take on the risks of trial. So from that point, my view is I can walk in thinking to myself, I'm free. I'm free to lay it all out, hold nothing back, fight as hard as I can, and I'm not so much stressed at that point. I can't imagine what it would be like knowing that if this doesn't go well, I don't go home at the end of the day. That would certainly have an effect on how calm I am, and how calm I am affects how good I can perform. The ability to be calm in a stressful situation is really, really empowering. kind of lost into that segue for a minute there. But anyways, so you can't really blame anybody if stuff goes wrong if you're representing yourself. That kind of makes sense. Otherwise, a pro per would just be languishing in the courts forever, doing case over and over and over again every time he makes a mistake. The corollary to that, right? We know this guy's going to make mistakes. You can't raise effective assistance counsel for making mistakes. That's what makes the denial of the right to represent oneself not harmless error, right? Because if that were the case, it would be a very hollow right. You just deny them and say, oh, it's just harmless error. Every time somebody appealed the denial of the right to represent themselves, the appeal would go nowhere because generally it'd be assumed that if it had an attorney, the attorney would have done at least as good a job, if not better, and there would never be any harm found. The court said basically we can't have a hollow right, so we're not going to use that standard. See, you did a good job, Daniel, of hitting some of the a lot of the kind of background reasoning behind that. I don't think there's really much I want to say here. The dissent talking about the contrary to societal goals of proper adjudication and the solemnity of the proceedings. This has been kind of my experience too. Pro per proceedings can be just bizarre. I generally find them to be kind of stressful and annoying when I'm trying to call all of my cases and a pro per case comes up and it takes a very, very long time. But it's still important. It's like I said, for that same reason I suggested before, that paranoid government theory, the ability to kind of make a spectacle of things is kind of like part of it, right? If somebody were ever in that kind of situation of a totalitarian government and they're at risk of being swept under the rug, they would want to be able to make as big a deal of it as they can, so that they can try and get their point across. Take that for what it's worth. Just kind of my own personal thought on that.
When I read this case, I instantly thought of Ted Bundy trying to represent himself because he had like a legal background, and was in law school at one point and stuff. And I mean, you're representing yourself on something that even if you're a well-trained attorney, you're not, more than likely not going to win. But I don't know if I wasn't around to watch that, but I've seen some footage from it, and it's just ridiculous,
Yeah, I've not seen that. I didn't know that he tried that or that he did that.
Yeah,
He fired his counsel, right?
Sorry?
I think he fired his counsel.
He did fire his counsel in Florida when they found out his identity because he got taken there, right? That's where he represented himself. I think it was in Florida.
I think so. Gotcha.
Yeah. He killed people in 4 or 5 different states. But he eventually ended up in Florida, and once they caught him, he killed these girls from this college campus, and they caught him, and he didn't have any ID on him, and he wouldn't identify it because back then they couldn't ID people without proper identification, documentation, all the rest of it. So he wouldn't ID himself, and when finally they were able to figure out who he was, he fired. I think it was a public defender or something. Somebody was appointed to him, and he just fired them and decided to represent himself.
It's surprising that doesn't happen more often. You hear a lot of stuff about serial killers, and I don't know how much of it's true or not, but a lot of the way that they're portrayed in the media, especially the bigger name ones, are people who have these kind of massive control issues and massive egos and the taunting of the government even. So it doesn't surprise me that they would just think and act like they're the smartest person in the room and try and take everything over.
Yeah, it was interesting to watch. But I like the line from the dissent that I liked was the criminal justice system should not be available as an instrument of self-destruction. Okay.
Let's see.
You could expect Lillian to come back and say, right?
You have Martinez versus Court of Appeal of California. It's just a reaffirmation of parental limitation. Get some more discussion in here from Justice Stevens. He doesn't think that this is really a necessary right when you have competent counsel available. Scalia kind of the antithesis to that, basically arguing that it's inherent in the Constitution and necessary for that paranoid government kind of reason. But there's also a limitation. You don't have the right to represent oneself in appeal. These are different, appellate proceedings are different. We don't have a Sixth Amendment right to counsel on appeal. That's, again, like we talked about, well, I guess I kind of glossed over that a little bit. It's more of that equality principle, right? A due process thing about that level playing field, that equal field. That's why a counsel is being appointed in that situation, not because of the Sixth Amendment itself. It's saying, look, government's going to engage in this process, got to be a level playing field, everyone's got to have a fair go at things. It's different than just the Sixth Amendment right to counsel. They're getting an attorney here, but not because of the Sixth Amendment. And because of that, they're able to kind of sidestep that issue. It's an equality issue, that's why you get the attorney. But there's no corollary, there's no implicit negative to that, the right to represent yourself on appeal. So McCaskill versus Wiggins, again, the denial of the right is not subject to harmless error. The right to self-representation does not preclude appointment of unwanted standby counsel as long as the counsel doesn't interfere with the client's control of the case. Dissent had some issue with this. How do you determine when an individual oversteps their boundary? My personal opinion on it is I don't like it. One court tried once to appoint me as a standby counsel for a client who was trying to go pro per. I told them I was not inclined to do so. They could take it up with a supervisor if they had an issue with it. The court kind of let the issue go. From an attorney perspective, I think it creates a really serious issue of, I mean, if the guy does have a right to represent himself, I mean, how do you prevent yourself from not stepping over that boundary, but at the same time, what are your duties? I mean, you don't want to be ineffective when you don't even have any control over the case, right? If he misses a necessary objection, you object, and he's angry at you for objecting because you didn't want you to, then where are you? I think it's
I didn't understand it
a
either.
weird and dangerous thing. I'm not a fan of it. I don't know any attorneys that are. I just feel like it's, I don't know, what is the purpose of that? You could just become a babysitter now for this case.
Yeah.
So basically an attorney can only voice their opinion when they're asked, is that by the defendant?
So you're like their co-counsel?
It's unclear. The court's basically saying that the appointment for that purpose, as long as the attorney isn't overstepping his bounds, isn't going to offend the Sixth Amendment and the implicit right to self-representation. So when court basically, the lower court said, hey, yeah, we'll let you go pro per, but you're having this guy.
Just in case it gets too messy and we need him to sleep
Right.
in or what? And fix everything.
But they're saying that's okay. The court's not really getting into what this individual's duties are, what the limits of those duties are. It's a very messy thing. It's just saying it's not, the Sixth Amendment isn't offended. But I don't know of any attorney that would be okay with that particular situation. Kind of like getting on an airplane and knowing that, like, as a pilot, and then you're going to go sit in the back row while one of the regular passengers flies the
Flight attendant will fly the pilot, go sit in the back.
I'm not okay with that.
So really quick, it seems to me when you look at it from a glance that the main thing of course, what they were looking at in the beginning when they decided what, the right to appoint a counsel was and why it should be is because of the effectiveness. It seems like that was a big issue, a big thing for them is they wanted to make sure again that it was an effective outcome, it was an effective hearing, that there was not a waste of time happening, that the levels were argued, that each person argued, just like today, it's very different when you have a judge up there deciding than the jury. The jury really doesn't have that level of expertise or education versus when you have a jury that is just going off of what the two attorneys that are there presenting.
Well, You're talking about like the reasons for having an attorney versus
Yeah, it seems
not.
like a lot of the times they were like, well, to be effective, in front of us, you need to have an attorney.
I don't know if they're really phrasing this from effectiveness, although that's part of it. I think the concern is that the Sixth Amendment says there's a right to counsel. So they made that requirement on the states because they determined it to be fundamental, because they said, look, anybody who can get an attorney in this setting gets one. The government always has one when they're prosecuting. Criminal defendants who can afford one get one. Their rights seem to be better applied when they have one. It's not a luxury, right? People need this. That's why they have the right to have it. But it's also the inverse of that is, basically you have the right to represent yourself if you want. It's not necessarily an effectiveness issue. It's that ability of
Being able to plead your case the way you want it to be played.
exactly. And we're gonna get in some. They add one of the cases that they added in this book over the last edition. We're gonna get into. I think that's next week. That it kind of talks about the suggested there's limits to the role of the attorney and the purpose for which they're supposed to be there. So there's certain limits and things that used to be done all the time. For example, conceding guilt on certain points in order to strengthen and argue other points. Used to be common practice. You'd see that in a lot of times in death penalty cases where they concede the guilt issue to preserve credibility and strengthen an argument in the penalty phase to try and avoid the death penalty. And then cases that started coming, and that was common practice, and then cases started coming down saying it's not okay when that's being done over the defendant's objection. Because it's, kind of in a way a very sophisticated mouthpiece for our clients. But they do have the right to put on their case, and that's what it is. It's their case. It's their matter. It's their life at stake. So if they want to take that in their own hands, they don't trust anybody else to have the ability to do that. Iowa versus Tovar, what's required for a waiver? Iowa was requiring a full admonishment. The defendant was waiving the assistance of counsel and deciding whether to plead guilty entails the risk that a viable defense will be overlooked. And by waiving the right to an attorney to lose the opportunity to obtain an independent opinion on whether it is wise to plead guilty. All right, so it's a pretty long kind of dialogue the court's kind of getting involved in there. So Iowa is requiring this admonishment. The court says that's more than what's needed. Sixth Amendment only requires the court to inform him of the nature of the charges against him, the right to be counseled, and the range of allowable punishments. Right? Here's what you're charged with. You have the right to an attorney. Here's how much time you can get. You still want to go along? Okay, that's good. One of the new cases that was added, Godinez versus Moran, dealing with the level of competency. So the defendant waives right from the attorney in the death penalty case and is found guilty. And he's essentially arguing he was competent to stand trial, but he wasn't competent to represent himself. Court says there's no double standard. Question is whether he competently waived, not whether he competently performed. So there's not going to be a double standard between whether one's competent to stand trial, and we get the Dusky principles are stated in there.
It says that a criminal defendant must have sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding and a rational as well as factual understanding of the proceeding against him.
So that's what's required in order for somebody to, the court to say it's constitutionally permissible for this person to undergo trial. That standard is pretty low in practice from what I've seen. It seems to be pretty threshold. I've seen some kind of pushback recently where we've been able to try and set something, it's still the same standard, but a higher practical application. So I've always been pushing for it, trying to get this notion of, I want people who can really weigh, or somebody who can do a risk-benefit analysis at a very basic level, I think. Because if they can't do that, then how are they able to make any type of rational decision on whether or not to flee and go to trial, which is kind of like the key decision they got to make in every case. I've not had, until recently, many judges that have really kind of thought about that as kind of being that kind of basic level. So I've seen things like doctors saying, it's like, well, like, yeah, he kind of understands what's going on, but you gotta explain things every, very slowly. You might have to go over things 3 or 4 times. But then it's like, hey man, if I'm in trial, I'm making decisions on the fly. I can't go stop the trial and go over things 3 or 4 times with him, right? So how effectively can you participate? Is he going to be able to help me out when I'm picking a jury? Like, hey man, look over there, try and pick out some cute reactions, or just even give me a gut instinct, or just pay attention for 10 minutes to what's going on. Can you give me any opinion at all? And sometimes I can't get that and still found competent. It's a little bit of an aside. The court here is saying like that standard is really kind of the same standard for representing oneself. You don't have some higher level just because you're deciding to be your own attorney in the matter. The only additional thing that is required beyond that competency to stand trial is that you make a knowing and intelligent waiver, right? So you have that right, so you have to say it. Obviously, if you've gone to, or if you're going to trial, you don't have to make a knowing intelligent waiver to go to trial. You're not really giving up any rights for using the law. Bizarrely, though, I've never seen a court, by the same token, ask the client for a knowing and intelligent waiver of his right to testify. If they say they're not testifying, it's usually left alone. I don't know why it is. But same level of competency. For either one. The court's pointing out the issue of competence is that they have to competently waive the right to represent themselves, not to competently represent themselves. There's a difference, right? As I said before, the court can't guarantee that an individual is going to be able to do a good job. Can you hear me okay, Trish? Yeah?
I think it's just my connection.
Okay, I just want to make sure you can hear me. I know my volume tends to go down, especially as I get tired. So if it does, just let me know, okay?
Okay, sure, thanks.
So the issue of competency is the ability to competently waive, not competently represent. That's the key. So if they're competent to stand trial, they make a knowing intelligent waiver, that's all they need to do. We have Indiana versus Edwards, another limitation on the right to represent oneself. Yeah. This is kind of conflicting here. The statement sets some limits based on mental competency, where they found the defendant competent to stand trial. The court didn't think he had the mental capacity to represent himself. Just kind of came with a kind of conflicting viewpoints, but that's kind of the newer one. So I treat Edwards as a little bit more controlling, although I don't know if it really is coming to the right result. I'd like it better from a defense standpoint. I think it's safer in the long run, but it still kind of runs afoul of some of those kind of paranoid government concerns that were raised in Beretta in the first place. We had a very strongly written dissent by Scalia and Thomas just kind of highlighting that there is not, or that there shouldn't be a double standard. But it kind of allows the court to put those safeguards there when someone's representing himself. So we've covered the right to an attorney, the right to get rid of, or to not have an attorney, and then the last couple of cases that we have cover the right to counsel of choice. Start with U.S. versus Gonzalez Lopez. Does someone want to take that one?
I'll do it. Where we have U.S. versus Gonzalez Lopez, and this was in 2006. And this case, we have a respondent who is Gonzalez Lopez, who was charged in the Eastern District Court of Missouri with conspiracy to distribute more than 100 kilograms of marijuana. His family goes out, they hire an attorney for him, but then he goes and meets with Lowe, who he later decides, who the defendant later decides he wants to represent, not the attorney the family hired for him, who has already gone to court and represented him and is appointed or is known as the attorney by the court. So when Lowe goes and asks to do kind of like a substitution of attorney, the court denies it a couple times and they don't let him represent defendant. Defendant goes to court represented by the first attorney that the court had appointed, that the family had gotten for him, and ends up, I believe, losing. And so he, since this was a paid attorney, he requests, he appeals. The Court of Appeals does say that the district court erred because they, it says the district court erred in denying Lowe's motion and they violated respondent's Sixth Amendment right to paid counsel, but they say that it was not, that the Eighth Court then concluded that the Sixth Amendment violation was not subject to harmless error review and the court granted certiorari. The court here says that what happened here was his right to his choice of counsel to represent him was violated by the Sixth Amendment. The appeals court, I believe, had said that he had to show that he had been prejudiced against to show, but the Supreme Court said he didn't have to, because what happened here was a structural error, not a harmless error, which is more, you go to trial, something that the attorney did causes you or your case to go awry, and now the appeals court can look at that and say, yes, there was an error in the way that he handled your case because of the law, he read the law wrong or something like that. Here it wasn't that issue. Here it was, they had violated his right to counsel. They had violated his rights to choose who he wanted to defend him. And it was paid counsel at that they were forcing him to have his first paid counsel. So here the court said that it was a violation of error and of the Sixth Amendment, and that it wasn't subject to harmless error because it wasn't a harmless error. It was a structural error. And the rule I got was deprivation of the right is complete when the defendant is erroneously prevented from being represented by the lawyer he wants, regardless of the quality of representation he receives. Because again, it was his right to counsel that was being violated. That's it.
Yeah, my apologies, my notes have clipped off and then cut and paste error. But you can see the kind of the corollary, right, between the right to counsel choice when you can afford it and the right to represent oneself, right? Just because getting an attorney to do a good job doesn't alleviate that kind of core concern, right? What if you have someone you don't want and you're concerned about the job they're doing, just because they do an okay job isn't going to alleviate those concerns, those issues. So that's why they're finding similar to the right to represent oneself and the right to make one's own mistakes, or the right to kind of choose who you want to have represent you stylistically if you can afford it, etc. That's not going to be subject to harmless error. Pro hoc vice, it's kind of the biggest wrinkle in this case because states do get a lot of leeway in who they are going to allow to practice. Pro hoc vice, is everyone here familiar with that? No. So it's like if you want to practice in another jurisdiction with which you aren't really sworn, right? You have an out-of-state attorney that's not sworn to practice in your jurisdiction. The court doesn't have to. The court can place limitations on that situation. They don't have to let that other attorney in. They can have prescribed rules as to how that attorney, if they do decide to let them in, how they can practice, usually alongside of another attorney who is sworn in that jurisdiction. But you can understand how that would be a limitation, right, to counsel. If the individual isn't, hasn't passed the bar in a particular state, they don't know those, that state's rules of courts, those state's particular rules, but hey, he's really good in front of the jury. He really knows how to make a good argument and how to really cross-examine a witness. I'd really like to have him, even though he's not familiar with the state's laws. It might be possible to get that attorney in, but they're going to be required to jump through certain hoops, and it's going to be okay for the court or a state to impose those additional limitations to be able to safeguard its own practice. The right to counsel of choice does not extend to appointed counsel. So if you don't have the money to hire your own attorney, if you have the money, you can hire whoever you want.
If you don't, you
certain
can't pick and
limitations,
choose.
but if you don't have the money to hire your own attorney, you can't just pick anybody to represent you. It doesn't work that way. Get that from time to time. Some clients that just don't necessarily like my style. I tend to be rather blunt. I'd rather have somebody else. I've had other, clients that have come up to me and repeat, come back on a new case. And they got a different attorney and they don't gel well with them. They want to come back to me, and I'm like, I don't get to pick and choose. If I did, I'd probably have too many, and I wouldn't be able to help anybody, and then no one would be happy. So. It'd be that situation like the vouchers, right? You'd end up with some people that might just be completely overwhelmed, and other people that might not have very many people, even though they're a good attorney, they just might not stylistically gel well. Morris versus Slappy, defendant's given a public defender, represents him in preliminary hearing, does an extensive investigation. That public defender is swapped for a second one due to medical reasons 6 days prior to trial. Trial starts on time. During the trial, the defendant requests continuance, but that second attorney maintains he was ready. Defendant requests more continuances, tells the court he considered himself unrepresented and wouldn't participate with counsel, later gets convicted. Ninth Circuit reverses, said Sixth Amendment would be meaningless without a right to a meaningful attorney-client relationship. So he's just meeting this guy. They haven't had a lot of time to work together. 6 days before trial, I have my doubts as to whether or not this guy is meeting with him 6 full days, maybe 30 minutes here, 30 minutes there, as the case is sitting in pre-trial. And if he's lucky, maybe an hour or two in a jail visit somewhere during that time. Not saying this attorney's not ready. If he's ready, he's ready. But that's not a lot of time to build confidence in somebody when they might be looking at a lot of time. Supreme Court reverses the Ninth Circuit reversal. So they say, no, that underlying situation is okay. There's no merit to the claim to claim the attorney needed more time to prepare. The request for continuance is untimely. So they're basically saying the attorney said he's ready. He's ready. We're not going to find that he's not just because the defendant is saying so without pointing at anything specific. But one of the key things is to say there's no right in law to a meaningful attorney-client relationship. There's no way for a court to ensure that, even if there was. How do you guys feel about that? Any thoughts?
I mean, I understand why they used the language they did, because then everybody would be like, they're unsatisfied with the communication or whatever with the attorneys. And on the other hand, it's like, if you can't communicate with your attorney, can they be effective in their performance or their defense?
Yeah, it's kind of nerve-wracking. If you think about it from a defendant point of view, you have this guy that wants to represent you, and you feel like he doesn't know you at all. How can he do a good job? It makes me nervous from an attorney point of view, because I feel like a strong attorney-client relationship is key to any case at almost any stage. You want to try and negotiate a case. If you don't know anything about your client, who he is, what he's been through, what he's done, we talked about that at the last class. You don't spend a little bit of time with them, how are you going to be able to make an effective argument to a judge or even to the DA as to why they should cut your guy a break, right? I like to get to know my clients so I can try and get the DA to like them. because if they like somebody, they're gonna want to help them out, right? Kind of the same thing at trial. If you really want to go all out and give it all you got, you really got to understand your client, what they went through, to be able to argue their position. Unless it's just that he wasn't there, he didn't do it. But if there's if he was there and you're saying something happened, but it wasn't exactly this, it was this other thing, right? Like he didn't hit his girlfriend, they were in a mutual scuffle, and this is what they're in a scuffle about, and you start getting into some of the relationship issues and to step into their shoes to be able to argue more passionately. It'd be much more effective, I think. But here the court's saying, look, you don't have to have that meaningful attorney-client relationship. You just got to do a good job. If he's ready and he can do a good job, that's all that's going to be required. We have concurrence by Brennan, says he feels this is it's not a case where we have to overturn it. But one of the things he thought might be a little bit more concerning is the right to continuity of the attorney-client relationship. And then he felt the court should have balanced the length of the attorney unavailability with the length of the relationship and the court need for efficiency. Although he here again felt the request for the continuance was untimely. So it might have been a different, well, I think here, as soon as the attorney said, look, I got a medical issue, I can't be here, if the defendant, the new attorney comes on, like, hey, I'm ready to go, but he wants some more time. Or if the defendant was like, hey, I'm nervous, I don't know you, like, hey, let's continue, we can chat about it. And they asked the court probably would have done it, right? I don't know many judges that close to trial, then the attorney just can't be there on the defense side at least, because we're generally considered, most judges say we're not fungible. Can't just swap one for another on the fly like that. If he's willing to wait time, I think most judges would have granted that. But here he doesn't do it until they're kind of already out. And any questions so far? We'll just keep muscling through. Kaplan and Drysdale charge versus U.S. This is kind of a bizarre case. Law firm represents defendant in a drug racketeering case. Defendant is not able to pay the firm afterwards because the Fed seizes assets under a federal statute providing for and conviction forfeiture of all assets derived from the proceeds of the violation. So the firm is trying to get paid. They've already done the work, so they sue, claiming the defendant was denied the right to counsel of choice. The Supreme Court says no, the defendant doesn't have a right to spend somebody else's money to obtain that counsel. There's a government interest in the forfeiture which outweighs his Sixth Amendment interest. One of the interests cited by the court is the need to lessen the economic power of organized crime. Firms arguing that the prosecutors are using this as a weapon to try and exclude certain defense attorneys, and that they're going to, potentially damage the criminal defense bar, because it might discourage some of the bigger firms from taking cases because they're worried they might not get paid at the end of the day. But at the end of the day, the argument doesn't win out. There is a limit to this, Lewis versus U.S. Difference between legitimate and illegal funds. So if an individual might be charged with drug racketeering, it would be one thing to kind of seize assets that are traceable to the illegal activity or to forfeit those assets to the government. It's quite another if the individual has their own property that is not linked to illegal assets. Let's say their mom is well-to-do and she pays for it, not an uncommon situation. In that scenario, since the funds aren't tied to the illegal activity, seizing any of these legitimate funds would be impermissibly stepping on one's Sixth Amendment right to counsel. How are you guys feeling so far? Good. Good.
Mm-hmm.
Any questions?
Not tonight.
Okay. Handouts working out okay. I feel like I'm kind of reading from it, but like I said, these are kind of like my thoughts, my summaries that have been distilled. It's kind of designed that way for all my brain goes. I can just go off that. But I figured I'd provide it to you since there's nothing that I would say in here that will test you on is not going to be in there. And I hope it'll help you out, but if it's finding it that it's like boring because it's just reading along as I'm also reading along, I can just, hold back, send it to you afterwards, or
No, I like having it to go along with the class, yeah.
or always open to criticism and pointers, suggestions, things that will make this topic more interesting. It'll be better when we get in the Fourth and Fifth Amendment, I think. There's also a lot to get through, and getting off topic can really set us behind. So. Right. No, that's all I got. Good.
Thank you.
Yeah, I saw that.
I thought about it.
But do you guys have days of court at all?
Not yet. I think we have that this year. Second semester?
Just kind of trying to watch out because sometimes those interfere, but last year we taught this on Tuesday and with it on Wednesday, maybe it doesn't, so.
Yeah, I'm not sure when I'll start.
Well, hope you all have a good evening and see you next week.
Thank you, you too.
I know.
Huh? Oh, maybe. Maybe, Brian. I know I bought a king size and then I was like, why did I buy king size?
Oh, yeah, my hat.
You're only gonna take one?
Oh,
Oh, okay. You need it if you pick up all of them. Woo!
I'm looking for something.
Don't say I never bought you dinner.
You know, I-
Oh my god. I'll finish your letter. I'll finish your letter.
I just got work from I come up in the morning tomorrow, cause I changed my schedule from 8:30 to 5 to 8 to 4 with half an hour. So I go in at 8 and then I
Yeah,
just
but you still have to
sit there by
do, like,
myself
case
until 8:30.
You still have to look up cases on LexisNexis.